in progress.
Hello, and welcome to today's webinar. My name is Melanie O'Brien, and I am the manager of the National NAGPRA program. This is the second webinar in this year, 2025. The first webinar was in January. Our goal is to hold these webinars every month on the third Friday of each month, as we did last year in 2024. If you're interested in finding previous recordings of these webinars, whether from this year or last year, you can find those on the NAGPRA programs events page where you registered for this webinar. We have maintained the recordings there. This meeting will be recorded, will be made available after today's call. If you object to being recorded, either by recording your attendance here at today's webinar or any questions you might ask, you may disconnect at this time. I will open a Q&A later in the session if you have questions that you'd like to ask. The topic for today are definitions under NAGPRA, and in particular, the definitions in the regulations. I'm going to start by sharing my screen. As I have done in the past, I don't have a presentation for today's session, but rather I've prepared some resources that you can find on our website in particular and other locations on the internet that are readily available. So in our conversation today about the definitions under NAGPRA, and in particular, the definitions of human remains and cultural items under NAGPRA, I wanted to, first of all, share with everybody that we do have a glossary on our NAGPRA program website. You can see where that glossary is. Again, nps.gov/NAGPRA will take you to our main page. The glossary lives under the reference library, which is under the Getting Started tab. And this glossary is just a translation of the definitions that are found in the regulations themselves into this table format. This is to assist you with printing if you wish to do so, or as a means of a quick reference to the definitions that are provided in the regulations themselves. It is my preference to use the regulations themselves, and 10.2 of the regulations is the definitions section. Again, if you don't know how to navigate to the NAGPRA regulations, that should be your first task. Bookmarking it, having it readily accessible, maybe even having it be something that opens for you every day. I know that I consult the regulations, if not on an hourly basis, at least many times a day. So section 10.2 of the regulations are definitions. And what I find helpful about this version of the definitions is that you can get a direct link to the definition itself. So if you want to share with somebody how to find the definition for the appropriate official, you can jump right here to this copied link and it'll take you right to that. So again, either source is fine. They are the same. They're just a slightly different format. And my preference, again, is to use the regulations themselves. So I'm going to jump to starting with the definition of cultural items and talk a little bit about the definition of cultural items in particular. And what I'd like to do today is go through in alphabetical order, since that's how the definitions are arranged. Cultural item first, then discuss the definition of human remains, and then we can discuss, well, that's not alphabetical order. Okay, then we'll discuss each of the kinds of cultural items after that. So cultural item is defined in the regulations to mean funerary object, sacred object, or object of cultural patrimony, according to the Native American traditional knowledge of a lineal descendant, Indian tribe, or Native Hawaiian organization. The term cultural item was not previously defined in the regulations themselves. It is, well, it's actually not defined in the statute. However, it is used in the statute in the definitions section. So let me pull up the statute also has definitions. This is the US Code at house.gov version of the statute. You can navigate to that from our website. It's available here on the law page. You can navigate directly to the act, and you'll see that the first section is the definitions, and you'll see that number 3 here in, again, the law itself uses the term cultural items, and cultural items means human remains and these other objects, which we'll talk about each one today. However, in the regulations, we define cultural items separately from human remains. And you'll note that cultural items does not include human remains in the revised regulations. If that seems interesting to you and you'd like to learn more about why that change between the Act and the definition in the Act and the revised regulations that were published last year, we've explained that, and you can find that explanation in the final rule, which was published published in December of 23 and became final in January of 2024. I'm going to ask that you please not raise your hands. We'll have time for Q&A at the end of the session. Okay, so to explain why the definition of cultural items does not include human remains, we have described that here in the final regulations in response to a comment that we received on the comments that we received on the definition of cultural items. And you'll see that the use of the phrase human remains or cultural items as separate terms is responsive to requests from Indian tribes. And while the existing regulations, the previous regulations, did not define cultural items, it was still, cultural items was used to include human remains in the previous regulations. So the change from cultural items to human remains or cultural items is only editorial. It does not have an impact on the applicability or scope of the regulations. But it is a responsive change, especially to requests from Indian tribes and NHOs to increase the sensitivity of the language used in the regulations to distinguish and differentiate between human remains and objects, between people and objects, essentially. So going back again to the definition of cultural items, it's just a broad definition that captures the specific definitions of funerary object, sacred object, and object of cultural patrimony. It does nothing really more, and the application of the term is nothing more than almost an abbreviated way of capturing all of those items in the regulatory language. The term cultural items is largely used in subpart B of the regulations to refer to the obligations of federal agencies and Indian tribes and Native Hawaiian organizations in responding to items that are removed from federal or tribal land. That's the primary use of the term. It's also used in other cases where the intention of the regulations applies to all Native American human remains or cultural items. That's again a kind of catch-all term that's used again in an editorial way, in a way that is intended to simplify the language in the regulations and to clarify the meaning and the subject of the regulations. So that's as much as I'm going to talk about cultural items. Again, if you have questions, we can get to those at the end of the session today. And we're going to shift to the definition of human remains. So again, the definitions here are in alphabetical order. I'm going to skip funerary object for now, and we will come back to that and start our discussion today with the definition of human remains. The definition of human remains is here on the screen. It means any physical part of the body of a Native American individual. This term does not include human remains to which a museum or federal agency can prove it has a right of possession. And then in addition to that definition, there are 3 subpoints to the definition. Human remains reasonably believed to be commingled with other material, such as soil or faunal remains, may be treated as human remains. Number 2, human remains incorporated into a funerary object, sacred object, or object of cultural patrimony are considered part of the cultural item rather than human remains. And number 3, human remains incorporated into an object or item that is not a funerary object, sacred object, or object of cultural patrimony are considered human remains. So again, this is the definition in the regulations. If we were to go to the Act itself, the statute itself does not contain a definition for human remains. You may be wondering now, how does this definition differ from what was in the previous regulations? Well, again, the best way to figure that out is to look at the previous regulations themselves. There are a couple of ways that you can do that. What I have on the screen now, and I'm trying to narrate a little bit of what the visuals are for those people who are calling in. What I have on the screen now is the Code of Federal Regulations, but you'll see that it's displaying not the current version of the regulations, but the previous version of the regulations. You can easily do this by changing the date that you want to see in the ECFR. It's a very handy tool. You can even look at a comparison of regulation across time. But for our purposes today, I have pulled up the previous regulations, and to do that, I just set the date to the first day of January 2024, before the effective date of the revised regulations. This gives you the previous regulations. And so if in the definition section, you'll see it's organized a little bit differently in the previous regulations. It's organized thematically by a central question. So to get to the definition of human remains in the previous regulations, we will scroll down to the question, what objects are covered by these regulations? And you'll see that here is the previous definition for human remains. Human remains means the physical remains of the body of a person of Native American ancestry. The term does not include remains or portions of remains that may be reasonably determined to have been freely given or naturally shed by the individual from whose body they were obtained, such as hair made into ropes or nets. For the purposes of determining cultural affiliation, human remains incorporated into a funerary object, sacred object, or object of cultural patrimony, as defined below, must be considered part of that item. Now, if you were only listening to my reading of both definitions, you may have heard some similar words. You certainly have heard a lot of similarities between the 2 definitions, the previous regulatory definition and the current regulatory definition. But there are some changes in the definition of human remains. And again, if you want to better understand those changes, the way to do that is to look at the final regulations, the final rule that was again published in December of 2023. And you can find in there comments and responses that deal with the changes in the definition of human remains. So I'm going to scroll down till I get there. I'll show you one of my favorite shortcuts here. If you're looking in the final rule for a definition, you can use the search function of your web browser to look for the term you're looking for, starting with the quote mark. So anytime that we are talking about a definition in the final rule, it will be set aside by quote marks. And so you can see here, those of you who can see on the screen, I did a quick search in the browser for quote mark human, and it's going to take me right to the second comment in this case that deals with the definition of human remains. So comment 38 of the final rule summarizes the comments that we received on the definition of human remains and provides the response from the Department of the Interior to those comments and explains the definition. I'm not going to read the summary of comments, but I encourage you to do so. There were quite a large number of comments that we received on the definition of human remains. I'm going to skip down to the Department of the Interior's response to those comments and the explanation of the definition in the revised regulations. Again, I'm not going to read verbatim what is on the screen, and those of you on the phone or those of you joining the webinar that can see it, I encourage you to read this for yourself, because if you want to better understand the definitions in the regulations, the first place to go is the final rule and the response to comments in the final rule. But I did want to point out a couple of important pieces of this response from the Department of the Interior. First of all, there's a wide variety of opinions about the definition of human remains, and especially how human remains that are incorporated into a cultural item might be identified. This is what the first paragraph discusses. The second paragraph talks about the addition in the regulations, in the revised regulations, regarding an admixture of commingled materials and as a part of the definition of human remains. We did receive comments asking us to explain what human meant in the term human remains. And so the third paragraph here refers to the sort of common understood meaning of the word human, and specifies very clearly that for this reason, because the definition and the act itself uses the term human remains, we cannot expand human remains to include the remains of other animals or other kinds of objects. So therefore, that's what this paragraph is explaining, why despite some requests that we did receive to include animal burials or animal remains as a part of the definition of human remains, we did not do so in the revised regulations. In addition, we received a lot of requests in the comments to expand the definition of human remains to include casts, 3D scans, or other digital data, documents, or records. We were unable to do that, to expand the definition of human remains. And again, that's explained here in this fourth paragraph. I wanted to jump ahead to the discussion in the regulations about human remains and the requirement in the revised regulations that human remains do not include, I'm going to go back here, do not include human remains to which the museum or federal agency can prove it has a right of possession. Okay. There's a discussion here in the final rule about whether or not biological samples, including DNA, soft tissue, or other biological remnants are a part of the definition of human remains, and whether that, therefore, they're subject to the Act or these regulations. There's a discussion here of what was in the 1993 proposed rule, as well as what was in the 1995 final rule related to additional parts of a body, such as bones, teeth, hair, ash, or mummified or otherwise preserved soft tissues of a person. Those were originally included as an example clause in the definition of human remains. There's then a statement here that comes again from the 1995 final rule. The Act makes no distinction between fully articulated burials and isolated bones and teeth. Additional text has been added excluding naturally shed human remains from consideration under the Act. This exclusion does not include any human remains for which there is evidence of purposeful disposal or deposition. The exemplary clause has been deleted. Again, that's a quote from the 1995 regulations and the explanation of the previous definition. In the final regulations from 2023, there's an explanation here from the Department of the Interior on the identification of human remains, and that it requires a case-by-case assessment in consultation with the lineal descendants, Indian tribes, and NHOs. Recent examples, meaning recently within the last several years, have demonstrated that the example clause from the 1993 proposed rule is beneficial in identifying human remains that are subject to the Act and these regulations, especially when it comes to hair samples taken from living individuals, coprolites, blood residue, tissue samples, and DNA extractions. The definition of human remains is intentionally broad and contains only one exception, the exception of the right of possession, which is discussed further below. The definition does not include a requirement for the human remains to be from an archaeological context of a certain age or from a deceased person. The definition does not exclude human anatomical collections used by medical schools for training or teaching collections. Again, the definition of human remains is purposely broad to ensure that any physical remains of a body of a Native American individual are included, with the one exception of a right of possession, which we'll discuss in a minute. I wanted to point this out because this comes up quite often. We often are asked what is included in the definition of human remains. And our response is, again, to refer to the definition of human remains. That human remains means any physical part of the body of a Native American individual. That again is the regulatory definition, includes any physical part of a body of a Native American individual. Now, frequently we will be asked or informed that a previous NAGPRA coordinator or curator excluded certain human remains from or certain body parts from being human remains subject to NAGPRA. And a museum needs to carefully evaluate that decision that was made in the past to exclude something, say, like hair samples that were taken either from an archaeological context or from a living individual. If they are the parts of a body of a Native American individual, then there needs to be an assessment of whether or not those fit the definition of Native American human remains and therefore are subject to the Act and the regulations. And again, we emphasize here in this paragraph that identification of human remains requires a case-by-case assessment. That means that the information that's available about the human remains needs to be considered in trying to identify whether they are subject to the Act and the regulations. And we have plenty of examples of these of different kinds of human remains that have been repatriated through the NAGPRA process. So moving ahead to the one exception in the definition of human remains. Again, the second sentence of the definition is about what the term human remains does not include. The term human remains does not include human remains to which a museum or federal agency can prove it has a right of possession. Now, this depends on understanding what the definition of a right of possession is, and I'm not going to necessarily go to that definition, but I think that you'll see the explanation here in the final regulations is about the addition of that sentence and the removal of the sentence in the previous regulations that referred to excluding human remains that were freely given or naturally shed. So again, if we want to compare the two definitions, you'll see that the second sentence in the previous regulations, this term, the term human remains, does not include remains that may be reasonably determined to have been freely given or naturally shed. Okay, so why the change in that definition? And you'll see the response here. We received a lot of comments in the revisions to the regulations to request that we remove that sentence entirely, the sentence about freely given or naturally shed. We agreed with the comments, particularly of the NAGPRA Review Committee, that stated, allowing museums and federal agencies to predetermine if such remains were freely given or naturally shed and not report them in an inventory deprives Indian tribes and Native Hawaiian organizations of necessary information. However, we disagreed, we being the Department of the Interior, that a museum or federal agency should be required to complete an inventory for human remains that were obtained with full knowledge and consent of the individual or next of kin. That's the definition of right of possession. In the 1995 rule, one comment requested clarification if human remains include blood sold or given to a blood bank by a Native American individual. In addition, in the 2010 final rule, two comments recommended excluding human anatomical collections used by medical schools for training or from the definition of human remains. In response, the department stated in 2010, they're not excluded from the inventory provisions. Medical schools that receive federal funds would not be required to repatriate Native American human remains obtained with voluntary consent of the individual or group that had the authority for alienation. So again, where a right of possession could be proved, those would not be subject to NAGPRA and therefore would not meet the definition of human remains. So it was through that, through those comments, as well as looking back at the 1995 final rule and the 2010 final rule, that we revised that second sentence in the regulations. We revised that sentence about what the term human remains does not include to require a higher standard of information for human remains that will be excluded from the Act and from the regulations. A museum or federal agency must be able to prove that the original acquisition of Native American human remains was obtained with the full knowledge and consent of the individual next of kin or the official governing body of the appropriate Indian tribe or NHO. In the Act, Congress acknowledged that a right of possession is qualified with respect to human remains and associated funerary objects. Congress did not provide for a museum or federal agency to assert a right of possession to human remains or funerary or associated funerary objects that are identified in an inventory. This is consistent with how Congress distinguished human remains and associated funerary objects from other cultural items. Then the discussion goes on to talk about how human remains and associated burial items cannot be owned in the same manner as other kinds of property. And therefore, we're applying that same distinction that Congress made in the Act to the definition of human remains, and clarifying that where human remains can, where a museum or federal agency can prove a right of possession to those human remains, then they are not subject to the Act or the regulations and can be excluded from the definition of human remains. This is feeling like I'm reading to you a lot, which is never the intent of these webinars. But I wanted to be very clear, especially here, because quite often when we do get questions about the definition of human remains, our way of answering them is to provide links to these specific paragraphs of the final regulations. So I want to really encourage all of you to read this very lengthy response because it details why the definition is the way that it is in the revised regulations. So I'm going to just show you that there are a few more paragraphs here, including an example paragraph for the definition of human remains. So this entire response to comment explains all of the parts of the regulation definition for human remains. As I mentioned at the beginning, the first part of the response talks about the commingled with other material. We received a number of comments about how human remains might be incorporated into cultural items or other objects. That is also then explained. So those changes from the previous definition are, again, in response to those comments that we received, as is the exception that's provided for in the definition of human remains. Okay. Again, if you want to look at more information, for example, say you want to read what the 1995 regulations say about the definition of human remains, you can find those previous regulations, again, on the National NAGPRA program website under Law and Policy, the regulations. We have links that are here for all of the final rules as well as all of the proposed rules. And so if you were to open this first link to the 1995 final rule, you'd be taken to a page that looks like this. For those of you that are on the phone, it's a page that lets you choose whether you want to view a full text of the document in PDF or a basic text format. At a certain point in time, I want to say it's 1996 or 8, the Federal Register did not convert the original text format into the online version of the Federal Register. So you either need to choose between a text format or the PDF format. The PDF format will come out in the 3-column version as the Federal Register prints it. And the basic text format will be, again, just a basic text, not formatted, not linkable. I almost always prefer the basic text format because it's easier to read on a computer screen than the 3-column format. So I have, again, pulled up for you, if you were to go to the basic text format, realize it's very large, you would be able to find in the discussion of the final rule from 1995, a discussion of the definition of human remains that was included in the 1995 regulations and why some changes were made from the proposed rule. Again, some of that's summarized in the 2023 final rule, but I wanted to be sure you're aware where you could come to find the discussion, the full discussion from the 1995 final rule. Okay, with that, I'm going to switch back to the definitions, and I'm going to go back to the definition of funerary object. So funerary object in the revised regulations gives an overall definition for funerary object as an object reasonably believed to have been placed intentionally with or near human remains. A funerary object is any object connected either at the time of death or later to a death rite or ceremony of a Native American culture according to the Native American traditional knowledge of a lineal descendant, Indian tribe, or Native Hawaiian organization. The term does not include any object returned or distributed to living persons according to traditional custom after a death rite or ceremony. Funerary objects are either associated funerary objects or unassociated funerary objects. And then the two subparts of the definition are a definition of associated funerary object and a definition of unassociated funerary object. Again, you can apply the same process to find more information about these definitions and how they vary from the previous regulations. In this case, rather than taking you to the previous regulations, I wanted to briefly show you the comment and response in the 2023 final rule for funerary object, because it includes a comparison of the definitions that is actually a little bit easier to see than maybe jumping between the different versions of the regulations themselves. So again, in comment 36 of the 2023 rule, you will see that we received 22 comments on the definition of funerary object. Just a reminder to hold your questions until the end. We will turn on the Q&A at that point, and you can ask your questions. There's a summary here in comment 36 of the comments that we received on the definition of funerary object. And then there is the DOI response to those comments and an explanation of what is in the final regulations. I think I might have, nope, sorry, my mouse is misbehaving a little. Let me make sure I can get here. Okay, so again, the response to comments includes a description of the changes that were made, as well as an analysis of the previous definitions. What I find very helpful is this table, table number 3 of the final regulations, which provides a comparison of the definition of funerary object. It starts with the definition from the Act itself, provides the definition from the existing or previous regulations now, and then the definition that is provided in the final regulations. And it is done in a way that you can see which words were added to the regulation, to the regulatory definition, and then how those that definition was revised to the version that we have in the current regulations. Again, there is more of a discussion here of those changes. The main change in the definition of funerary object between the Act, the previous regulations, and the final regulations is the inclusion of the phrase, according to the Native American traditional knowledge of a lineal descendant Indian tribe or Native Hawaiian organization. And in fact, that phrase appears in every definition of a cultural item, including the definition of cultural item. Again, the phrase is according to the Native American traditional knowledge of a lineal descendant Indian tribe or Native Hawaiian organization. And then there's a paragraph just below that table that explains that additional language. And you'll find that the same paragraph is included in the discussion of every definition of a cultural item. We did receive requests to strengthen the definition and to change according to be as determined by. But we were unable to make that change because it would be inconsistent with the Act itself. Museums and federal agencies are responsible for making determinations under the Act and the regulations, but they must do so after consulting with lineal descendants, Indian tribes, and NHOs. The addition of according to Native American traditional knowledge is to ensure meaningful consideration of information during consultation. Again, you'll find language similar to that throughout the final regulations in each instance where that language has been added to a definition. You will also see here in the definition and discussion of a funerary object, again, why the Department of the Interior included that according to Native American traditional knowledge in the revised definitions, again, for all cultural items. We're starting here with funerary objects, but this applies to all of the cultural items. And you'll see there's a comment here on the screen that the definitions of cultural items by this addition of according to Native American traditional knowledge will lead to more informed decision-making and help avoid the lengthy and costly delays in disposition or repatriation. In crafting the definitions of cultural items, so all cultural items, Congress clearly intended that the definitions will vary according to tribe, village, or Native Hawaiian community. And then there's a citation to the Senate report on page 4 to that quote. Consultation, which is required throughout the Act prior to any determination, is how an Indian tribe or Native Hawaiian organization shares the information needed to identify a cultural item. We often get requests for assistance in how cultural items are defined, and how whether a museum or an Indian tribe can ensure that a certain item meets those definitions. And again, we often point to this language from the Act itself, from the Senate report about the Act, that definitions will vary according to the tribe, village, or Native Hawaiian community. So the definitions that are provided in the Act itself for cultural items are intentionally broad. Congress intentionally made them broad with some limitations, but again, to allow for that variance of different cultures and communities. This is a good opportunity to remind you that you can find the Senate report, again, on our website under Law and Policy on the Law page. You will see a link here to both the House report and the Senate report. I've gone ahead and pulled up the Senate report for you. This is on page 4 of the Senate report. There is a section called Definitions, and this is a discussion of congressional intent for these definitions. And you'll see there's a discussion here. It's the bottom of the third paragraph on the screen right now, that the committee, and that means the Senate Committee on Indian Affairs, made every effort to incorporate comments and address concerns of members of the scientific and museum communities with regard to the definitions in the Act, while at the same time recognizing that there are over 200 tribes and 200 Native Alaska villages and Native Hawaiian communities, each with distinct cultures and traditions and religious practices that are unique to each community. Accordingly, the definitions of sacred object, funerary object, and items of cultural patrimony will vary according to the tribe, village, or Native Hawaiian community. It goes on from there. There's a lot of really helpful information here in the Senate report related to the definitions. This piece about the broad sort of parameters of each definition to allow for the variances across tribes and communities, I think it is a very important one to keep in mind as you're reviewing any of the definitions, but certainly the definitions of funerary object, which is what we're focused on here. You will see that the definition of associated funerary objects relates specifically to the location of the human remains, and that is known. This is a repeated and I guess perpetual misunderstanding or challenge of understanding the difference between associated funerary objects and unassociated funerary objects. And rather than to go into too much detail here about that, I will again just refer you to the discussion in the final rule, which is quite extensive, about the definition of associated funerary objects and the location of the human remains being the defining feature that separates associated funerary objects from unassociated funerary objects. This was a major issue that we at the Department of the Interior felt needed to be clarified. The previous regulations were confusing, if not also slightly misleading, in that the definitions did not line up exactly with the Act itself. And so the effort here in the final regulations, in the revised regulations, is to better align this definition in particular with the definition in the Act itself. I'm going to skip ahead to the last two definitions that I wanted to cover today, and that is definition of sacred object and the definition of object of cultural patrimony. Object of cultural patrimony is defined again in the regulations using In large part, the definition from the act itself as an object that has ongoing historical, traditional, or cultural importance central to a Native American group, according to the Native American traditional knowledge of an Indian tribe or a Native Hawaiian organization. Again, that same phrase used here. The addition to this definition from the previous regulations and from the act itself is to include this next sentence, that an object of cultural patrimony may have been entrusted to a caretaker, along with the authority to confer that responsibility to another caretaker. So this comes from many comments that we've received on the definition of object of cultural patrimony that indicate that just because there is a caretaker of an object, it does not negate the fact that that object could have still an ongoing importance that's central to a group itself. And then there are two additional pieces of a definition for an object of cultural patrimony: that the object is reasonably identified as being of such importance to the group that it could not be alienated, appropriated, or conveyed by any person, including the caretaker, regardless of whether that person is a member of the broader group. And the object must have been considered inalienable by the group at the time the object was separated from the group. These two pieces, again, largely come from the definition in the act itself, and the clarification here is to break them out into these two subcategories. Again, make a reference to the role of the caretaker, which does not negate the overall central importance of an object, but is included here that the object could not be alienated by that caretaker. I'll go to sacred object next, and then discuss those two a little bit more. See, the definition of sacred object means a specific ceremonial object needed by a traditional religious leader for present-day adherence to practice traditional Native American religion, according to Native American traditional knowledge of a lineal descendant Indian tribe or Native Hawaiian organization. While many items may be imbued with sacredness in a culture, this term is specifically limited to an object needed for the observance or renewal of a Native American religious ceremony. In, again, both cases, there is a lot of information on the definitions that you can find in the final rule, again, published in December of 2023. And let me just skip. Here we go to comment 46, which is a summary of the comments we received about the definition of object of cultural patrimony. And in the department's response, a discussion of that responds to those comments and explains the language that is used in the final rule, in the final regulations, and this definition. Again, a lot of similarities here in the discussion about congressional intent, the intentional breadth of the definition from the act itself, as well as, again, to allow for that variance across communities. If we then skip down to the definition of sacred object, you will see that that definition, discussion of that definition includes, again, very, very similar discussion of the breadth of the the breadth of the definition in the statute itself, but also a little bit more detail on some of the requests that we received to make changes to the definition of sacred object, and where we were unable to broaden the definitions as requested by some comments to better align with the language from the House and Senate reports themselves, in addition to the language from the Act itself. Additional discussion here in response to comments about whether or not a sacred object can be interred. And again, some clarification on the language from the act and a discussion of that language, again, the breadth of it. This discussion in the final regulations and in the definitions themselves, obviously, the discussions in the 2023 final rule about those definitions and about changes to those definitions, as well as looking at previous regulatory definitions, are important for anyone who's engaging in this work and in trying to identify or evaluate or better yet, make a request for repatriation of one of these kinds of objects. I want to stress again that the helpfulness of this section of the Senate report in particular in better understanding and explaining congressional intent on the definitions that are provided in the act itself, again, as well as the definitions from the act. I guess what my overall message is for today, and I'll go ahead and stop sharing so we can move into some questions and answers. My overall message for all of you today is that these definitions are not a mystery. There is not only the definition themselves that you can turn to, the discussion in the 2023 final rule, discussions in the 1995 final rule, as well as discussion in the Senate report from 1990, can really be helpful in better understanding the nature of these definitions, the language in the definitions, and how they need to be applied throughout the process in the regulations. So I again feel like there was quite a bit of me reading today, but I can't emphasize enough how important it is to be sure that you're consulting all of these resources when you're dealing with an issue under NAGPRA, when you're trying to make a decision as a museum or federal agency under NAGPRA, or if you are an Indian tribe or Native Hawaiian organization that is trying to make a request for repatriation. Understanding of these definitions is critical to any part of the process under the regulations. So with that, it could be that I was having some trouble screen sharing. I hope that's not the case, but I'm going to go ahead and turn on the Q&A. And if I was unable to actually share my screen, as I got at least one comment about, I will go ahead and pop into the chat for today links to all these pages that I was referring to, so you can easily jump to any of these definitions yourself. And feel free to go ahead and put your questions in while I am copying links. As a reminder, you can use upvoting in the regulation. Sorry, looking at the regulation. You can use upvoting as a way of indicating that you have the same question that someone else has, and that will prioritize it for me to answer. I will provide all of the links that I used today. And I really hope that you were able to see. So I'm giving you links to all of the sort of primary sources that we reviewed today. But again, all of these you can find by navigating through our website, either on the law page or the regulations page, or other parts of our web page. Again, I can't stress enough how much information is out there and available for anyone to consider. Okay, so I'm gonna sort these by upvote and say, let's go with the first one. not directly related to definitions, but I was wondering if you're able to talk about whether the National Park Service has been, will be impacted by ongoing administrative orders, which may relate to submissions to the Federal Register. Yes, we have been answering that question quite frequently, and I can provide an answer to that question. As is very common during any kind of change in administration, there was a temporary suspension of the delegated authority to publish notices in the Federal Register. For the Department of the Interior, this came through a secretarial order that was issued on January 20th, 2025. Federal Register notices related to NAGPRA are progressing through the internal clearance process that is required by that secretarial order. Publication timelines may be extended in the short term during the leadership transition. But I want to stress and remind everybody that statutory and regulatory deadlines require museums and federal agencies to submit notices by certain dates, and delays in publication do not alter those requirements for submission of notices by museums and federal agencies. We are experiencing, again, a short-term delay in our publication in the Federal Register. This is very common during any change in administration, and we expect and hope to be resuming publication as soon as that internal clearance process is clarified and established. A related question: in reviewing the notice database on the NAGPRA website, it doesn't appear that any notices have been published since January 17th. That is correct. We have not published any notices since January 17th. Again, this is a very common situation during a change in administration. I can tell you that in 2017, in January of 2017, we published notices on January 12th, 2017, and the next notices were published on February 24th. So there was a little over a month of a delay at that time. Again, a very common part of any transition in administrations. The second question is, I understand that the Assistant Secretary for Fish and Wildlife and Parks now has the authority to approve notices for publication. However, it appears that the previous Assistant Secretary has stepped down. Can you tell us who is the new or acting Assistant Secretary? And Lisa posted a press release about the Secretary of the Interior. We do not at this time, there is not an Assistant Secretary for Fish and Wildlife and Parks that has been nominated. Though that position, the Assistant Secretary of Fish and Wildlife and Parks, is a Senate confirmed position, meaning that the President nominates that person and the Senate confirms that position, the person for that position. And they have not, there's not been a nomination yet for that position of Assistant Secretary. However, there is a process in place to provide that internal review of notices for publication. We do not expect that we will have to wait for a Senate confirmed Assistant Secretary in order to be able to publish notices. We fully expect that the process will go through and the internal process will continue, and we will be publishing notices hopefully very soon. I will say that's also not unusual for notices to have to go through this kind of review and approval process, including to the Assistant Secretary. That was actually the process that we had in place prior to 2017. There was additional internal review process. And some of you may remember in 2016 and prior, notices could take months to go through that process to be approved to publish. We're hopeful that we won't have that situation, but we are still waiting again on the process. Again, I want to please ask you to not raise your hand, but put your questions in the chat. It's easier for us to track the questions as well as to respond to the questions. We do have over 260 people on this webinar today. which makes it difficult to manage hand raising, and we prefer to manage question and answers. Okay, let me clear the ones that I have answered. A follow-up question, should we still be submitting notices so they can still go through the internal process? Yes, please. You have an obligation under the regulations to submit notices by certain timeframes. You must do that. The delay in publication does not change the responsibility for museums and federal agencies to submit notices within those timeframes that are required by the regulations. So there's no delay in terms of submissions and receiving. We continue to receive notices, and we will respond to you immediately with a temporary tracking number, or I should say with a notice ID number. It's just that it might take a little bit longer than it had previously to go from submission to publication. Oh, good. Some confirmations that you were able to see my screen. That's good. And some other people who could not see the screen. So I'm sorry about that if you were not able to see my screen. Again, I put links to everything that I showed in the chat. Okay, let me resort. Again, you have the opportunity to upvote questions so that they will raise to the top of my screen. The next upvoted question is, thank you for the great information. Can you speak to delays in applying for repatriation grants, if any? Should we proceed as planned for the FY24 grants? Thanks for the question. You should proceed as planned for grants, for grant applications. Let me clarify a little bit, because the question asks about repatriation grants and 2024. We are currently in the fiscal year 2025, but I will say again, as I've said many times, we have funding currently available for repatriation grants. So there is money from fiscal year 24, so the last fiscal year, there is funds available for repatriation grants. We revised the process this year so that we could always have the opportunity for anyone to apply to a repatriation grant at any time during the year. So there are funds available right now for repatriation grants. So please submit repatriation grant applications as soon as you are ready to do so. Regarding the fiscal year 2025 grant opportunities, there are 2 grant opportunities. We have consultation and documentation grants, as well as repatriation grants. And those notices of funding opportunity are open and accepting applications on grants.gov. The National Park Service is processing all financial assistance actions, including reviewing applications and obligations of award, pending review with some recent executive orders, but we are still accepting those applications. However, we do want to note that, as always, this is not unique to this year, always, NAGPRA grants are contingent on funding that is made available through Congress in annual appropriations. And for those of you who are aware, we do not have yet a final fiscal year 25 appropriation. Right now, we are under a continuing resolution that goes until the second week of March. So we do not yet know what that total funding amount will be for the fiscal year 25 NAGPRA grants, but that should not prevent you from preparing that application and proceeding to submit an application. You can find out more information again on our website under the grants tab. And I'll just say one more time that there are funds available for repatriation grants. So please apply for those today, and you can apply under the FY24 Notice of Funding Opportunity in grants.gov for repatriation grants. Okay. The next question is similar. If there were any changes to the deadline for NAGPRA consultation or documentation grants. No, that deadline has not changed. You can find it again on grants.gov. You can navigate to the notice of funding opportunity. If you don't want to search grants.gov, you can go to it through our website. All right, so currently anthropologists have had some success in obtaining DNA from soil. Does this mean that the soil needs to be considered for repatriation? Some additional comments. This is an excellent question. And that someone commented that there has been a precedent set for this in the past and the soil has been repatriated. Again, a decision about whether something, including DNA that might have been extracted from soil, is human remains under NAGPRA, is again a case-by-case decision. It will have to do, in this instance, it might have something to do with how the DNA is obtained. I do not quite understand the process by which DNA can be extracted from certain. I don't understand it. So let me just say a lot of this will depend on the circumstances. It will also depend on consultation with Indian tribes and Native Hawaiian organizations. Obviously, first and foremost is identification that DNA is Native American is one. And then as Tanner has helpfully added, the definition of human remains does include that human remains believed to be commingled with other material, such as soil or faunal remains, may be treated as human remains. Again, it's up to the museum or federal agency to make that decision about what are human remains under NAGPRA. Again, the input from Indian tribes and Native Hawaiian organizations for particular cases will be critical to making that identification. Okay. Great question. Thanks. In a claim that does not have human remains, how much information, traditional knowledge should the tribe provide to provide a claim under the category of unassociated funerary object? Okay, so I'm gonna fix a couple language points here. We have revised the regulations to discuss a request for repatriation. And so in your use of the term claim, understandably, it makes perfect sense. But I just want to clarify what we're talking about here is a request for repatriation, and a request for repatriation of something as an unassociated funerary object. So in that case, you'd be following the process under section 10.9 of the regulations. And in 10.9, there are certain elements that are required for a request for repatriation. And the question here is, how much traditional knowledge does the tribe need to provide? Traditional knowledge can be provided in many ways. It can be provided orally through a consultation. Doesn't necessarily or isn't necessarily only provided through a request for repatriation. Likewise, we are aware that much of the traditional knowledge that Native American individuals or tribes or Native Hawaiian communities have is sensitive and in many cases cannot and should not be written down. Therefore, there is no requirement in the regulations or the Act for a tribe or a Native Hawaiian community to disclose sensitive information about its traditional knowledge. Now, there is still a requirement in the process for repatriation for an Indian tribe or an NHO to identify that an object meets the definition of an unassociated funerary object. The question about unassociated funerary object is a little bit easier to answer because again, remember the definition for funerary object is about intentional placement with or near human remains as a part of a death rite or ceremony. So where an Indian tribe can show that as a part of a death rite or ceremony, these kinds of objects were placed with human remains, it meets the definition of funerary object. If the human remains, the location of the human remains that are associated with that object are not known, then the object might be an unassociated funerary object. Again, funerary objects are either associated or unassociated. If they are associated, if the location of the human remains is known, those are associated funerary objects. All other funerary objects are unassociated funerary objects. Now, there are additional parts of the definition of an unassociated funerary object, and in a request for repatriation, an Indian tribe may want to indicate which of those definitions are met. That the funerary objects in question are from a specific burial site of an individual, or there are, I think, 6 different sub parts to the definition of unassociated funerary object. But I think your question is probably asking more about, do you need to disclose specific information related to the traditional knowledge to identify that object? And the answer is no. You need to make your request, and your request needs to state that the object is an unassociated funerary object according to traditional knowledge. And then the museum needs to respond to that request. We've actually received quite a number of questions in this area, in particular where a museum's response asked for additional information. And I want to be clear that the way the process is laid out in the regulations, again at 10.9, is that there is a request for repatriation where a tribe asserts that a certain object is an unassociated funerary object, sacred object, or object of cultural patrimony, and perhaps includes some specifics how that object satisfies that definition. The obligation of the museum or federal agency then is to respond to that request and say either the request satisfies the criteria and repatriation will occur, or the request does not satisfy the criteria. Where a request does not satisfy the criteria, the museum needs to explain why and provide an opportunity for a tribe to provide additional information. And I'm clarifying this, and I'm kind of going into some depth here because there's no threshold of information that a tribe must provide in that initial request for repatriation. Are there ways that maybe you could add to your request for repatriation? Absolutely. And I would very much encourage any tribe to include information from the definitions, as I mentioned, as well as perhaps some of the language that's in the Senate report could help in identification of an object and how it meets the definition. Okay. All right. Next upvoted question is, the museum I represent has modern-made objects acquisitioned from Native American artists that include human hair, and the source of the human hair is unknown. If we have a bill of sale or a deed of gift from the artist, would that count as the right of possession? It's a good question. I think that, again, this will be a case-by-case analysis based on the record of that acquisition from the artist. Certainly if the artist is still alive today and you can get additional information about the human remains that are included in the object, it will be important to determine whether or not the object is, whether or not the object is our human remains, and that the hair that's incorporated are human remains under NAGPRA, and whether there is a right of possession. It comes down to probably, in some respects, whether the artist can show a right of possession that is then transferred to the museum. So again, a lot of the particulars here are going to be important, and I would encourage any museum that has similar contemporary works of art that include human remains to be sure that there's a clear indication from the artist that they had permission to incorporate those Native American human remains into the object. Right. Do you have recommendations for dealing with uncertainty surrounding whether human remains meet the Native American prong of the definition of human remains? For example, if there is uncertainty about whether the remains are Native American or Caucasian. The recommendation here would be to focus on the definition of Native American in the regulations. So you've identified that they are the parts of a body. The key then to meeting the definition of human remains is whether they are parts of a body of an individual with Native American ancestry. And in those cases, you need to look at the definition for Native American. And again, I think it's important to all of the context, all of the available information, including the general collection history of your institution, is going to be important in making that assessment of whether or not the remains are Native American or not. And again, I would encourage you to provide an opportunity for input from Indian tribes through consultation on that decision of whether the remains are Native American or not. I will stress that the threshold for a decision on the question of Native American is whether it's a reasonable decision. So again, taking the information you have available, what do you know? Often when I'm asked these questions, people are focused on what they don't know. You can't focus on what you don't know. You need to focus on what you do know to make the decision about whether that information shows that the remains are Native American or not. That's the decision point. Okay, the next upvoted question is, what is considered proof of possession when it comes to museums and federal agencies having sacred or religious items to excuse items from NAGPRA? Great question. Let me clarify this question a little bit by saying that a proof of a right of possession does not exclude a sacred or religious item from NAGPRA. What it does is it gives a way for a museum to refuse to repatriate. So that object, if a museum believes that it has a right of a possession to an object, and it must still include that object in its summary of Native American cultural items and is responsible for receiving and responding to requests for repatriation of that object. It is through that process that the museum can then prove, and again, prove that it has a right of possession. So, it's a higher standard to allow this refusal to repatriate on the part of a museum or federal agency, and that was intentional by Congress. There is a clear intent by Congress that the right of possession standard, when it comes to denying a request for repatriation, is a high standard that a museum must make. This brings up something that's often raised in responding to requests for repatriation. Perhaps a museum might ask a tribe to provide that proof that the museum does not have a right of possession. That's not the tribe's responsibility in the process for requesting repatriation. It is up to the museum to prove that it has the right of possession, and under that right of possession refuses to repatriate. Okay, let me sort by upvotes. The next question is, in regards to the exception of right of possession, what if donations are made due to financial reasons, either getting paid or preventing costs, say, of a funeral? So maybe donations of human remains, either for payment or to avoid costs. I think that this gets to the right of possession, that human remains are not covered under NAGPRA, where a museum or federal agency can prove they have a right of possession. That proof, the information needed, is the written documentation about that donation. It needs to be, as Audrey helpfully linked to the definition and the right of possession, there needs to be full voluntary consent from the individual who is donating their body or a part of their body. And that needs to be clearly demonstrated in a written record. That would be the level of proof required. Certainly in the history of Native Americans, as well as the history of this country, there is not always clear proof of voluntary consent to donating a part of a body in historical records. So any museum that is going to make that assertion of a right of possession needs to be able to prove right of possession to those human remains, and that should be done through that proof of a voluntary consent from the individual or from the next of kin that provided that donation. The next question is, what if you have an artifact such as a rattle that may not have teeth in it, but you don't know without further analysis what's making the rattle? Okay. That's a case where you would definitely want to include that rattle as a part of your summary. Again, a summary is a general description of any holding or collection that may contain cultural items. And so in that case, it would be through the consultation process where an Indian tribe might identify that rattle is connected to their culture, and that those kinds of rattles typically used some rock or bean or something else to make the rattle sound. Or alternately, their traditional culture is that those rattles were used and were made with human remains, such as teeth. So again, it will depend largely on the consultation on that rattle to identify whether or not it might contain human remains. And then if it does contain human remains, again, the two parts of that, the number 2 and 3 in the definition, talk about human remains that are incorporated into a cultural item are a part of the cultural item. So if the rattle were a sacred object and had human remains incorporated into it, it would still be a sacred object and subject to repatriation that way. If the rattle is determined or a tribe through consultation agrees that the rattle is not a sacred object or any other kind of cultural item, but it does include teeth, then the museum would want to, again, consider the information to determine if that meets the definition of human remains. And again, it'll have a lot to do with not only the consultation, but the additional information the museum has about the rattle, when it was acquired, how it was acquired, and where it was acquired from. I want to just give a great shout out to my team that is assisting with answers to questions today. It's very helpful to have you guys here because I certainly cannot get to all of the questions, although I'm kind of come close today. When it comes to a request for repatriation for unassociated funerary objects, how would you handle it if the tribe indicates that a specific area is generally related to burials, similar to how many Western individuals would think of as a cemetery, but expressly do not know whether certain objects are specifically part of a burial practice? They consider the area sacred, but the objects that would not meet the definition of sacred object and would like those objects repatriated and reburied. The request goes on to say that I guess is there a problem with going forward with repatriation of things where there is some legitimate uncertainty about whether those things are covered under NAGPRA. In answer to the second part, no. Proceeding with the NAGPRA process based on information from consultation is what the process is about. In this case, where we might be talking about cultural items, so unassociated funerary objects, sacred objects, or objects of cultural patrimony, consultation is central to the process, but the decision point comes from a request for repatriation. So if an Indian tribe wants to make a request for repatriation of whatever the object is that's in your collection, and they do so as an unassociated funerary object, your responsibility here is to evaluate the request for repatriation. So where an Indian tribe has asserted that those objects are unassociated funerary objects, your responsibility here is to decide whether they've met that requirement, whether the request satisfies that criteria. In this case, if the Indian tribe isn't really sure, maybe doesn't want to make a request for repatriation, then the conversation continues. But when there's a request for repatriation and when an Indian tribe has asserted that they are unassociated funerary objects, the obligation of the museum is to respond to that request and to either agree to repatriate based on the request or refuse to repatriate. And in refusing to repatriate, the museum needs to clearly state why it's refusing to repatriate the objects that were requested by the tribe. Okay. All right, it looks like we are just about out of time, and I only have 5 questions left, and some of them are about being able to see and thank you, so I'll skip right over those. If our museum acquired an object that is thought to be human remains, we would verify the item's identity, verify how acquired, consult with the tribe, and then the tribe would need to make a formal request for repatriation. Is that correct? Yes and no. There are a few additional steps when it comes to human remains. And those additional steps are required because there is what lawyers would call an affirmative duty for a museum to make certain decisions about human remains so that they can be repatriated upon request. So certainly if you have an object that is considered human remains, then you would definitely want to consult with the tribes. You would then need to complete an inventory and publish a notice. And then after that notice is published for human remains, the tribe would make a request. There's a different process when it comes to summary, cultural items, and human remains. And that difference is intentional because of the importance and significance of human remains in particular. And thank you again, Audrey, for providing the breakdown. And we have a similar breakdown of the other process, but the steps involved for human remains are there. There was a request for a better definition or to discuss the definition of possession versus custody in terms of loans to a facility. And thank you, Audrey, for including the definition of custody and the definition of possession or control, both of which discuss loans. And so please consult those definitions. Furthermore, I'll say that when it comes to possession or control, this is a great place to look at the final rule published in 2023, the comments and responses on that topic in particular. Okay. What would make the museum the experts on items they are unaware of based on their theoretical epistemologies acquired through a biased ethnocentric education system? Wouldn't it be easier to start collaboration to identify items and gain knowledge through consultation? Absolutely, it would be easier to start collaboration to identify and gain knowledge through consultation. And actually, NAGPRA requires that collaboration, and consultation obviously is required by NAGPRA. Is it easier to start that way? Absolutely. Is it required that you start with consultation? No. In both the process for repatriation of cultural items and repatriation of human remains, the first step is for the museum or federal agency to gather the information they have. Now, the information they have will likely reflect, as the question says, the epistemologies that are acquired through biased ethnocentric education system. Absolutely. And that's why that's not the only step in the process, but it is in part the first step, because a museum does have information and it needs to gather that information to begin the consultation process. So both the process for cultural items and for human remains first starts with a museum gathering the information it has, providing that to tribes as the basis for consultation, to then improve upon that knowledge, as the question says, through the collaboration of consultation. And that's an excellent way, thank you for the question, to close out today's session. So I appreciate everybody joining us today and all of the questions that you asked. And I apologize if I missed some of the questions towards the bottom. We will save those questions for sure. And please join us next month on the third Friday for another National NAGPRA Program webinar. Thank you.